from daily list item 11, the rupees 6350 of 130.
Why were both the parties called?
Yes. In the last occasion, coordinate bench had asked to make appearance of the petitioner Fulmoni Manji, and she has come.
For what purpose?
Actually, there was a dispute that they have the opposite party private respondents. They took the stand that Fulmoni Manji has died, and they made they are near agnates, and then applied for mutation of the land because she was married to another village.
Who's for the private party?
Mr. Saha is
You took a stand that Fulmoni Devi has died.
On the report of the circle officer.
You are the circle officer.
Circle officer.
आप देख लिया इनको physically दिख रही है.
Yes, ma'am, but the report was given in the 2008 of 9. It was a very bad report.
ऐसा हो सकता है कि 2008 के बाद कोई जीवित होके चले आया हो. ऐसा तो नहीं हो सकता ना. You can verify her identity.
Much on spot.
आधार है आपके पास.
हाँ लगा दिया. They had verified from the village, and the villagers also supported and said that Fulmoni Manji is alive. The counter is there.
Counter affidavit is
counter has been supplied to me today.
So what is the cause of action of filing of this case here?
Yes. Now what happened?
The land is standing in the name of Fulmoni Devi.
Yes.
Okay. Now they applied for mutation.
Yes.
Okay.
And within 15 days, the circle officer mutated the land of those parties. They made an application saying that Fulmoni Manji has already died.
So that order has to go.
No.
Now fresh order has to be passed.
Yes.
कुछ भी होता है. Where is the order of mutation?
Page 19 of petition.
Page.
Page 19 of petition, your ladyship, annexure 2.
This is the impugned order.
Impugned orders Annexure 3,
Annexure 3 is the impugned.
Annexure 4,
Annexure 2, 3 and 4.
2, 3 and 4.
So you give them an opportunity of hearing and pass fresh order. You verify their identity, whatever. As per your supplementary affidavit, Fulmoni Devi is now alive.
Yes, your ladyship, we have conducted one on-spot inquiry, and as per in presence of the Mukhya and everyone. And the report is on, and your ladyship may have page 13 of supplementary counter affidavit. Your ladyship. If I may have permitted to read. The event page has been given on page 13 from 6 para 9.
So according to you, some inspection was conducted
Yes,
and she
sir.
was found to be genuine.
On the basis of the oral evidence of the villagers.
Then under such circumstances also fresh order has to be passed by the circle officer after giving an opportunity of hearing to the applicant. Because they may have something to say. It is an unilateral report from your side.
Yes.
They may have something to say on the report. Right? And in case you are unable to decide as to whether she is the correct person or not, you can just observe that this has to be declared through a competent court of civil jurisdiction. You cannot go on like this.
That was observed by the order of the Commissioner, your ladyship, and annexure 26 of the writ petition, page 26 of the writ petition, ladyship. If I may place before your ladyship.
Annexure?
Page 26 of the writ petition, your ladyship. Annexure 4.
Yes.
Even if it is assumed that the petitioner and the recorded tenant are same, then also the claim of the petitioner is about title and their share in the land. This issue can be declared by the competent civil court. Taking into consideration all the above facts, I see no merit in this case and revision and no reason for interference.
You have to pass fresh order after hearing. We do not know what stand. They may accept that she is the recorded tenant. Or they may produce some contrary evidence. We do not know what is going on. As on date, the concerned person is present over here. And no opportunity of hearing has been granted to her. आपको समझ आ रहा है सर्कल ऑफिसर साहब? इनकी आइडेंटिटी देख लीजिए, इनको क्या बोलना है, सारा रिपोर्ट की कॉपी उनको प्रोवाइड कर दें। आप ले लीजिएगा रिपोर्ट, आपको जो आपको वहाँ बोलना है फ्रेश ऑन, ठीक है। देखिए, फॉर द लर्नड काउंसिल फॉर द पार्टीज pursuant to order dated 25th September 2024, the Circle Officer Gamaria, Saraikela Kharsawa, is physically present before this court. Petitioners बोला गया था, कितने लोग आए?
सन्स है,
सब आए हैं?
सब आए, एक बड़ा लड़का है
अच्छा ठीक।
और दो बाहर बैठा हुआ है।
The petitioner number 1, Fulmini Manji. No, the counsel for the petitioner has produced a lady before this court and claims that she is Fulmini Manji. He submits that the petitioners have come to this court. The learned counsel submits that the matter arises out of mutation, order of mutation, wherein the recorded Rayat, namely Fulmunji, recorded Rayat, namely Birdhan Manji, कौन है recorded Rayat? Which was passed by on the assertion made by the private respondent that Fulmuni Devi has expired. We have submitted that since Fulmuni Devi is present in the court, the impugned orders be set aside and the matter be remitted to the circle officer for fresh consideration. A supplementary counter affidavit has been filed, which is taken on record during the court proceedings, which is taken on record. And as per the supplementary counter affidavit, some inquiry was conducted on the spot, and it has been mentioned therein that Fulmuni Devi is alive. The learned counsel appearing on behalf of the private respondents has submitted that an opportunity may be given to the private respondents to respond to the report which has been submitted by the counsel for the state, and such opportunity may be given by the circle officer who may decide the matter afresh after granting an opportunity of hearing to the petitioners as well as private respondent. He submits that the identity of Fulmuni Devi is the main point which is required to be considered in the present case. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it appears that the impugned orders were passed by the concerned authority on a ground that, inter alia on the ground that Fulmuni Devi has expired. However, in this writ petition, it has been asserted that Fulmini Devi is alive and who is petitioner number 1 in the present case. Now, a supplementary affidavit has also been filed by the state disputing that, confirming the status that the Fulmini Devi is alive, but certainly the private respondent are entitled for an opportunity to contest the identity of the petitioner number 1 in the present case, namely Fulmini Devi. And they have a right to respond to the inspection report submitted by inspection report filed through the supplementary counter. In view of the aforesaid facts and circumstances, all the 3 impugned orders are set aside and the matter is remitted to the circle officer for passing appropriate order on the application for mutation filed by the private respondents. In accordance with law, after granting opportunity of hearing to the petitioners as well as private respondent. इसको copy मिल गया? The supplementary counter affidavit has already been served upon the petitioners as well as the private respondent. It will be open to them to respond to the supplementary affidavit before the circle officer. The circle officer shall pass a fresh order in accordance with law within a period of 2 months from the date of by 20th December आप कर दीजिए. Election है 22. The parties to appear before the circle officer on 26th of November. 26 नवंबर को आप लोग appear हो जाइए इलेक्शन के बाद. 20 दिसंबर तक कर देंगे. हो जाएगा ना 15-20 दिन में. This petition is accordingly disposed of in the course of business. 3 ऑर्डर है, सर्कल ऑफिसर, एपिलेट, रिविजनल, तीनों होगा. तीनों ऑर्डर से.
Please paste from supplementary list for final result item 1 WPS 6387 of 2016.
How many exempted employees were there?
101 list was furnished by the establishment. 10. But that list is there.
In the fresh order, you say that all the records are manipulated.
We doubt it because the the report, inspection reports also suggest that there is a discrepancy between the wage register, the income that they have generated. Those are annexure 2 and 3, where the concerned enforcement officer has reported that there is a discrepancy giving the detailed figure. And for that reason, they were asked that you furnish the quarterly return. Now, interestingly, my lord, when they appeared before the authority, first they said it is old record, I will not be able to give you. Second time they said that there are two replies. One reply they said it is old, we will not be able to give you. Second they say that the employers have left and they had said that we have our own employees have left. They have their own PAN card and they have said that we'll file our own return. But the law mandates that the employer has to deduct it. So twofold explanation they gave when the authority said please produce this. Because the figure that one interestingly further, my lord, the amount of salary that they show is much more than the work order given by Tata Steel. Tata Steel has given a work order saying that this will be the rate payable for the employee, security guard. Now they are saying that we are paying more than that. So that also enforcement officer says is unbelievable. What you receive, you will not give more salary than that. Certainly less than that you will give what you receive from the
What was the nature of complaint?
complaint. Yes, that is annexure 1, my lord. That
Can you read that?
my lord.
Read it.
Yes. The undersigned complainant KC Chaudhary in capacity of manager coordination in the agency Messrs. Bravo Security Private Limited submits some of the details of the scandal being run by managing director of the company Captain S.N. Pandey. In regard to the PF contributions and deposits in respect of the employees account for your kind information with a request to take up immediate legal action, deputing your team of observers to observe and verify the records of the said company detailed as under 1. The said agency had approximately 275 number of employees right from very commencement of the company's transaction from 1992. Please note that hardly 45 number to 55 number of employees have been enrolled to PF membership right from 1992. The contribution offered to the above employees only for 10 to 12 days of working in place of their working through the month of 30 days right from 1992 all along. 4. You will be surprised further that contributions soon showing the wages salary at rupees 500 per month to most of the employees, leaving some of the employees without bothering the minimum wages that can do. If
Pause
you,
here for a moment.
I'm sorry, madam.
The grievance was that the employees are not even being paid the minimum wages.
Yes.
That was the grievance of this person.
And PF contribution is not also.
Actually, because he claims that the minimum wages are also not being paid to them.
Yes.
Right? That was his grievance.
And thereafter, my lord, if you go to the books of the company, you will find that the by the company at such and such
That no officials of the company at 11 old Adityapur enrolled in PF.
enrolled in PF account, and the undersigned complainant is also excluded from the same, who is an authentic and empowered for work of PF in the agency. If you verify the record of the company, you will find that payment at 20% through the monthly deposit challans deposited hardly at rupees 15,000 to as rupees 3,500 right from 1992, whereas this amount should have been rupees 45,000 to 50,000 each month right from 1992. Calculating amount among the strength of the employees, 275 members on the basis of minimum wages likely to be paid to employees. On the light of the facts and figures at detailed above, you will observe that roughly 22 lakh, 25 lakh and more of that has been escaped by Captain S.N. Pandey on account of employees PF during the span of 4 years as on date. If you call on records asking bankers of agencies, Central Bank of India, Aditpur branch, State Bank of Bikaner and Jaipur, Shastri Nagar, PO Kadma, Jamshed to submit the statement of account, the agency operating its account with the complete details such as the name of the company, check number, date, amount of check issued to Bravo Security Service Private for the total years of account, you will find that this agency has drawn around rupees 1.2 crore or more of that during the 4 years, and accordingly you may easily estimate the length and width of the scandal of the employers in regard to employees of
That's
PF.
right. We have seen that.
If you ask,
Now, first order, let us see the first order.
first order is on page 33.
You come to page annexure 2.
Yes, my lord. This is to the this is by the enforcement officer. He writes to the assistant provident fund commissioner.
Read the first line.
I'm sorry.
We verified. First line. We verified records papers produced by the establishment which are as under.
As ordered by as ordered by number 3801 dated 13/2/07, we verified records paper produced by the establishment which are as under 1. Attendance and payment register including excluded employees, list of excluded employees, sample quotation showing rate of different type of security personnel, balance sheet with profit and loss account for 2003-04 to 2005-06. The summary of perusal of our paper records is as under. Gives year, receipt of security.
That's right,
check.
you can proceed further.
According to the directors of the company, the company is engaging 100 such employees whose salary wage is more than 6,500 per month. Hence, compliance in respect of them has not been reported, treating them as excluded employees. The director could not provide us the records reflecting the quantum of salary oblique wages shown in the balance sheet, as it is the surprise to note that during 2005-06, total of salary wages comes to rupees 1 crore 14 lakh 329, but balance sheet profit and loss account shows 55 lakh 59,666. That is just 50% of the amount has been shown. On the other hand, during 2003-04 and 2004-05, it has been shown nearly 1.5 times. The establishment could not provide us party-wise deployment of security guards and receipt of payment from those parties. However, the book bank sheet shows the total receipt during the year, which has been reflected above. The salary statement for
So this particular discrepancy was recorded as back as on
this is dated 16/3/07.
2007.
Yes.
It was relating to the period. Which period is this?
Yes, period
3,
he
4
says
to
2000.
5, 6.
Yes,
So
5.
even at that point of time, they did not have the records, and it was matching, mismatch. There was
Yes,
complete
yes,
mismatch.
because what they showed was not matching with the receipt that they
That's
had. Towards
The next document is
Then the next document is
examination of balance sheet and observation.
on scrutiny of the IT return and balance sheet for the year 2002-03, 2003-04 and 2004-05, it is observed that there is huge deviation in the salary of the
That's
wages
it. We
shown
have
in the
seen
balance
that there
sheet.
is a complete mismatch. Then
Then
there
I
is
have
the order
annexed-
of assessment.
Yes, first order is annexure 3, page 33. This has been set aside.
Just a moment. This has been set aside by which order?
Annexure 4 at page 37, order dated 6109 on violation of principle of natural justice.
Just a moment. So basically, it was the grievance was that it was passed on the basis of a report submitted by the departmental representative, and without serving them a copy
Yes,
of
the
such
order-
report, the order has been
Order has
passed.
been passed.
So is it these two reports? It is referring to these two reports.
These reports, yes, my lord, and the other material that is there, they have received it. The records
Okay,
are
they
there.
received it.
Yes,
They have
everything
annexed it also, and it is here.
Then,
Then
the
fresh order was
annexure
passed.
5 is passed.
Yes.
May place it. In the matter, whereas Messrs. Bravo Security Services Private Limited, M11 Old Housing Colony, Aditpur, Jamshedpur, herein referred to as establishment, is admittedly an
You come to
establishment.
proceedings.
I'm sorry, madam.
You come to proceedings.
Findings.
Proceedings.
Acha, proceed, yes, madam. Shri S.K. Singh, member HR, appeared to represent the establishment. Shri R.R. Pandey, enforcement officer, appeared on behalf of the department. Later, LSB BP Sinha, enforcement officer, represented the department. The establishment was asked to submit appointment letters in respect of all excluded category of employees, copies of Form 16 issued to such workers, TDS salary sent to Income Tax Department year-wise, payment register, salary statement for the notice period, copy of agreement, work order of the parties where they were deployed. On 16/2/09, Shri Singh submitted a letter requesting for supply of reports submitted by squad of the enforcement officer and departmental representative, which was basis of determination which was made available to him. On 23/2/2009, Shri Razi Hassan appeared on behalf of the establishment. He produced salary register of excluded employees for the period 0103 to 06/04 and 0105 to 06/07. Balance sheet for 03/04 and 04/05 along with IT return. Later, the establishment submitted one petition dated 19/5/09 Sri LSBP Sinha, enforcement officer and departmental representative, was directed to go through the petition and submit his comment and submit his report. On 9609, Sri Sinha filed his report while letter dated 9609. A copy of the same was sent to the establishment. Sri Razi Hassan and Sri Jaya Ranjan appeared on 23609. He submitted reply dated 23609 on verification report of departmental representative. As above, the case was closed and orders were reserved. Finally,
Where are these two reports? 9609 and 23609. It must be there in this record.
yes. Nine six zero nine, your lordship will find it at this volume which starts with the Sanchika. One volume, the first page is Brevo,
Yes.
and the second is the order sheet.
Yes.
There your lordship
9609.
will find it. 9609 at page 41 and 42, 40 and 41 end.
This page numbering is not there.
Handwritten top, may I show it? This is the Sanchika.
561 C slash.
This 41 top.
So R2 41.
But it is the official
Yes.
record it will
Yes,
be the
page
reverse
number.
order.
Page number would be
40 and 41.
40. Yes. This is the report.
The establishment has claimed
No,
for
this is not the report. I'm looking at the report. I want to see the report. File is report dated 9609. Where is the report? This is the report.
9609. This is my lord, this says my lord gives the because there
They
is a
also gave a
recommendation.
report. They also gave a response to that report.
2360.
It is 9609.
Yes, it is 9609.
Twenty-three.
609 is the name.
Running page 367 is the submission on behalf of the establishment, 23609, and the report of 960.
But two places, another submission your lordship again find at page 360.
I want to see 9609 report.
96 is at page 40.
No, this is not a report.
Because has recommended therein, madam.
There is a covering letter of 10609 also. Where is that?
Madam, may I place just page 367 once more?
367.
Yes, where they have given the submission.
The Roman 2, petitioner
Yes,
hereby
it
acknowledges the
acknowledge
receipt of your letter number.
dated 10/60 along with copy of enforcement officer's report and the order sheet, both dated
So,
9/6.
this where is the report 9609?
The order sheet is there, madam.
Order sheet is there, 9609 report is the basis. Anyways, you read further the interview order. You read the interview
Yes.
order.
After going through the proceeding findings, after going through the proceeding records, petition, reply submitted by the establishment and the report of the departmental representative, and having applied my mind, it is found that the case is mainly concentrated on the issue regarding grant of benefit to the establishment in respect of wages, salary paid to the excluded employees who were drawing more than 6,500 per month. It is observed that the salary of the excluded employees were always rupees 1 lakh and above in every financial year, which is liable the employer to deduct income tax from the salary and deposit it with the income tax department, followed by submission of its prescribed return for non-production of this valuable quarterly return by the establishment taking shelter of it being 6 to 7 years old cannot be accepted. This is because as per IT Act rules, records relating to minimum 7 years required to be preserved. The explanation of the establishment evidence is that the employer has failed to deduct income tax from the salary and has not complied with income tax department or has prepared fake salary register to evade grant of membership under PF scheme. In this way, the request of the establishment fails, which was reheard as per direction of the Honorable High Court. Accordingly, the dues under Section 7 of the Act assessed previously, that is rupees 28,78,215 by order dated 24/3/08, is to be taken as the dues and interest under Section 7(2) need to be quantified on date. Thus, the establishment is required to deposit the dues in the following manner. The calculation is given made out month-wise.
This calculation you have taken from which register? And from where have you taken it? You say that the documents are fake. What is the basis of this calculation?
But the amount that they have disclosed, from that we can take.
So, on the one hand, you rely upon their disclosure, and on the other hand, you say that they have made up the accounts.
Because they did not produce the TDS certificate.
Yes.
And it was from the document it appeared that the salary that they have shown was on the higher side.
Yes.
So when there is non-production of the document, the assessing officer can only pass the order on the basis of the material available on record.
So, this salary has been taken under what head? This is with respect to April, the entire amount.
The wages that they have disclosed, that this is the amount of wages we have paid.
Yes. So
But the
whatever they have
excluded
disclosed, you have accepted it, and you have calculated on that basis
Yes.
only, and you say that the documents are fake, isn't it?
But there is no other manner in which the amount could have been quantified. It is only the disclosure that they made. And the supporting documents, and there is a discrepancy from the records that they have
You
produced.
see, if there is a discrepancy, you will accept one record and reject another record. Fair enough. But you say that the entire documents are fake, and this is how you do it. They have their audited balance sheet,
Yes.
right? If they do not comply with it, the only reason for passing the order is that they have not produced the income tax returns.
Yes.
Returns they have produced, whatever it is, they have their own balance sheet. We are not here to interpret the returns and the balance sheet.
Yes.
We are very, very clear on that. We will not interpret anything over here. And merely because a person does not produce the TDS certificates, or the person is not in a position to show that the amount was deducted and it was deposited in the income tax department, from where do you get that the amount of salary was less than rupees 6,500? Is there any finding?
But the report says, my lord, the work order that was issued to them
Yes.
from the employers where they had deployed the security guard, that showed the quantum lesser than what they are paying. So it cannot be possible that somebody will receive 100 rupees and pay to 150 rupees. If he is receiving 100, he at best can pay 99 rupees or 90 rupees.
We do not know. There
But
is
that
an
report
agency.
says-
There is an agency who is employing number of security personnel. Right? They may get money in the name of their for the purposes of the services which they are provided.
Yes.
Right? 100 rupees. But they may not pay the entire amount to the person.
Yes, certainly that is what I am
They
saying.
will not.
They should not pay. And here it is found that they are paying more than 100 rupees. They are receiving 100 and paying more than that. That is unbelievable. That the
From where do you get this? That
But
they
the
are.
enforcement officer has given a report
Where
that
is
from
that?
the work order, annexure.
That
to
is
our
why the report, ultimately the report which was prepared. Where is that report?
But that order sheet I have placed before.
No, order sheet is not the report.
But that was served upon him.
Where is it?
So in a reply, he acknowledged that the order sheet has been served upon him.
Fair enough. We want to see that because the order has been passed on the basis of report again,
Yes.
right? Where is that report?
No, that
The
is
response of the report is here,
Yes, this
but
is the
you have
report, my
not.
lord.
That particular document is missing from your
My lord,
records.
it is there in the form in the order sheet. Is the only.
Let us see the report, the so-called report which you say is the report.
9609, page 40 and 41.
Read it.
The establishment has claimed for benefit in respect of excluded employees. According to establishment, drawing salary more than 6,500 on going through the payment register in respect of such category of employees, it is found that during year, it is given to 2003, 2004, 2004, 2005, 2005, 2006, and quantum of salary per month is given. Annual income thereafter on basis of that is calculated. According to the above position, it is found that all such categories of employee have drawn such annual salary which are very much taxable. If such category of employees were drawing such salary, the employer must have deducted income tax from the salaries salaried employees and have deposited with income tax return. Such returns are given in quarterly return named TDS. In the establishment, in spite of demand of such returns, the same was not made available as the plea that they are not having such return with them. This act of the establishment indicates that the establishment had not actually paid such quantum of salary, and the same has been prepared only with a view to raise the quantum of wages salary for relaxation of balance sheet. This has been done to save the establishment from income tax liability. In this way, the claim of the establishment regarding excluded salary is fit to be rejected. And
You see, as per the payment register, this is the amount which is shown. Did you examine any of the employees that how much they were getting? You could have examined each one of them. कितना पैसा मिलता है?
ये तो reply में कह रहे हैं, detail नहीं दिया इन्होंने. I'll just place the reply once, my lord. What was the difficulty, my lord? Kindly see the response. Page 367
And you calculate this amount on the basis of this wage register only.
But that was the document available with the authority.
There was another set of documents also available, that was the audited balance sheet.
Audited balance sheet will give the total amount,
Yes.
and the wage sheet
But
will
but
show.
there was a mismatch.
Mismatch
between-
was, my lord, the receipt that they had, the amount they had received, and the balance sheet what they show as per the returns, what they have received, balance sheet they are showing something else. So that was a mismatch. The amount was not matching. Now what they say, my lord, why we could not, my lord, they simply said at page 366 that the record called for a more than 6 to 7 years old, and it is not always possible to retain all records. 7. That the petitioner made all efforts to locate those employees to obtain their PAN of income tax, but unfortunately none of them could be located. That the report dated 9609 sent to this petitioner with your letter dated 10/6/2009 appears to have been prepared with prejudiced mind, as the same has been signed and prepared by the inquiry officer also, which proves the department is prejudiced. Then that neither of the involved employees of this period is presently working, nor they are at present traceable. In such situation, even if the amount are assessed and deposited, there will be no beneficiary to receive the amount. One more reply that they give is at page 360. Now there they give a different version.
$360.
360.
Written submission
On behalf of the applicant,
or the establishment 19/5/2009.
23309. Just before the
Yes.
income tax. Here they say, second paragraph, that despite our best effort, we have not been able to locate the employees who have already left our employment. Next, that they had informed us they were having their own permanent account number of income tax, and as such they insisted that they would be filing the IT return directly under their own PAN. So, they say that we have no record of any of the employees, 111. We don't know where 111 employees have gone. And then thereafter, they say we have no record. Then they say that our employees had said that we will do it ourselves. But it is the mandate of law that they have to deduct the TDS. So they are not furnishing
deducted the TDS.
and not furnishing the details of any employee as well. They say we have no record of any of the employee. The employer is very strict that he will have no record of his employees. But they are security guards. They will certainly do the KYC before employing any person. keep their records. This is a security agency, they must have also undertaken
You
police
come to page
verification.
number 357.
357. Yes, madam.
The salary and wages has been disclosed,
Yes.
right? This is 9 crores 636, whatever the figure is.
96 lakh 36,109.
Okay, 96 lakhs 36,109. So when you compute this amount, you take this wages. Which wages you take?
Not of the excluded employees they had submitted list.
Yes.
There. Those for whom they were not filing the contribution. Not all the employees. They were filing for 40, 50. For
If you take for excluded employees, and you say that their wages was less than 6,500,
yes.
right? So then 101 employees, then at best you could have assessed them as at 6,500 per head, not more.
The assessment
Not
was
more,
done as per their
because
disclosure.
because you see, if you say that they were receiving wages less than 6,500 and therefore they were covered, what is the maximum you could have assessed, even if we take the best judgment assessment? 6,500 per month, per day,
100.
per person,
Yes, for 100 employees.
for 100 employees, nothing more than that. So, how will you compute
But
it
that
on
will
the
come
basis
to,
of?
madam, that will come to 6,500 will 100
What
will
is the
come
percentage?
6,50,000. 6,50,000 per month. Here it is taken as 22,73,000.
Yes,
Less than that.
22 lakhs
22,73,000 monthly.
monthly.
Yes. Even I calculate at 6,500, it will come to 6,50,000 and 6,55,000. So he has computed less than that.
Monthly?
Yes, monthly he has computed.
Where is that computation?
Page 40, the amount is wages
Page 40.
40, the calculation. It goes my lord, if first for April he gives 2,73,000 wages, monthly wage. Then for May he gives 2,79,000. July he gives 2,79,000. He has not crossed 6,50,000 in any month. If I take for 101 employees.
Yes. So therefore, 2,73,000, right?
Yes.
If we take the from where do they get this figure? This is the payment made.
Must be the minimum wages. Because payment made, they have claimed more than that. They have claimed more than
This
lakh
is on the basis of minimum
I,
wages.
that is not written, but I believe so. It must be on minimum wages. Because if I take even more than 6,500, they say, so it will come more than 6,55,000 per month. It comes for 2 lakh if I divide it.
Yes, respondent.
It will come 2,700 at that point of time per
In the
month.
entire records, there is a complete mismatch between whatever registers you had produced and your audited balance sheet. There was a mismatch, right? Then at page number 43, the tribunal records a finding that in this case salary register, income tax return, balance sheet reveals that these persons were receiving wages more than 6,500. So assessment of these persons cannot be termed as legal. The fact that there was complete mismatch has not been taken into consideration? Which salary register and which document showed that it was more than 6,500? There was complete mismatch. The tribunal has not even called for the record, it seems. 2 pages order he passes.
Now let me argue what my friend has bothered your lordship to go into all these evidence, etc. The way in which I have prepared my case notes.
I was trying to figure out whether this order can be sustained.
Yes, notes. This order can be sustained, and my submission would be that this petition has to be dismissed, and with a cost, because this is sheer abuse of the process. I will argue to this subject to what my lords will say. Now, let's kindly see the order first. The impugned order here, Annexure 6, page 42. These are sheer misuse. My friend is taking to evidence under 226 or at best 227. The appeal, page 42 I am placing. The appeal in this case is preferred against the order passed by the PF authority under section 7 capital A of the Employees Provident Fund.
Page number 42.
42 impugned order was in this writ petition.
Yes.
Annexure 6, page 42.
Yes.
The appeal, I am repeating this. The appeal in this case is preferred against the order passed by the PF authority under section 7 capital A of the Employees Provident Fund and Miscellaneous Provisions Act 1952 hereinafter referred to as the rules. The case of the appellant is that the appellant is a private limited company registered under the Companies Act. It was engaged in the business of supplying security guards to several establishments. The appellant was covered under the Act and making the contribution regularly for its eligible employees. The PF authority initiated a proceeding under section 7 capital A of the Act and assessed the dues for the excluded employees who were drawing salary of more than 6,500. The impugned order is illegal. The case of the respondent is that the appellant failed to pay the dues for eligible employees and no excluded employee was included for assessment. This was their case, that no excluded employee was included for assessment. 4. It is contended that the appellant is not liable to pay the contribution for the excluded employees. The learned advocate for the respondent supported the impugned order. The applicability of EPF Act to the appellant establishment is not questioned. 2F is quoted. Just I want to place this. Excluded employees का meaning क्या है? An employee who, having been a member of the fund, withdraws the full amount of his accumulations in the fund under clause so and so 69(2). An employee whose pay at the time he is otherwise entitled to become a member of the fund exceeds 5,000 rupees per month. Explanation, I am not concerned. The definition makes it clear that persons who had withdrawn all their benefits and the persons who pay dearness allowance exceed rupees so and so. In this case, the salary register, income tax return and balance sheet reveals, the tribunal has examined all this, that these persons were receiving wages more than rupees 6,500, whereas the requirement is 5,000. Ceiling is 5,000. And these persons were getting the salary more than 65,000, and that is the finding returned by a appellate forum, that is a tribunal who has the power to reappreciate the evidence also. So assessment for these persons cannot be termed legal. There is no averment in the whole writ petition as to whether this finding is perverse, whether this finding which has been returned that these persons were getting the wages more than 6,500 is wrong. There is no statement at all in the whole writ petition. I can refer one paragraph to the last one. This is one, and kindly see the date thereof. The date on which this order is passed, 23rd March 2011. On the top of it, my lords will find at page 42, first page, order date is 23rd March 2011. And this writ petition is being filed when? 2016. 5 years they waited. For what purpose? Merely because this High Court set aside his order, remanded the matter back. Now he is bent upon me, this authority, EPFO. 5 years they slept, like Kumkaran. And after 5 years he is coming to the High Court under 226. And therefore my submission is first, that the writ petition has to be dismissed, not in limine at this stage also, in view of the judgment of the apex court notes. I rely on a judgment for this purpose.
Victor,
For this purpose, Lords, that the writ petition cannot be entertained after 5 years from the date the order was passed. For this purpose, I rely upon a judgment 2014 4 SCC, page 108,
yes.
Chennai Metropolitan versus TT Murli Babu. The relevant paragraphs are, Lords, paragraph 16 and 17. Para 16 notes I want to place at report page 117. 16 notes. Thus, the doctrine of delay and laches should not be lightly brushed aside. A writ court is required to weigh the explanation of heard and the acceptability of the same. The court should bear in mind that it is exercising an extraordinary and equitable jurisdiction. As a consequence, as a constitutional court, it has a duty to protect the citizens of the rights of the citizens, but simultaneously it is to keep itself alive to the primary principle that when an aggrieved person without adequate reason approaches the court at his own leisure or pleasure, the court would be under legal obligation to scrutinize whether the lease at the belated stage should be entertained or not. Be it noted, delay comes in the way of the equity. In certain circumstances, delay and license may not be fatal, but in most circumstances, inordinate delay would only invite disaster for the litigant who knocks the door of the court. Delay reflects inactivity and inaction on the part of the litigant. A litigant who has forgotten the basic norms, namely procrastination, is the greatest thief of time. And second, law does not permit one to sleep and rise like a phoenix. Delay does bring in hazard and causes injury to the lease. Para 17 is more important. In the case in hand, though there has been 4 years delay, in my case 5 years, in approaching the court, yet the writ court chose not to address the same. It is the duty of the court to scrutinize whether such enormous delay is to be ignored without any justification. That apart, in the present case, such belated approach gains more significance as the respondent employee being absolutely careless to his duty and nurturing a lackadaisical attitude to the responsibility and remain unauthorizedly absent on the pretext of some kind of ill health. We repeat, at the cost of repetition, that remaining innocuously obvious to such delay does not foster the cause of justice. On the contrary, it brings injustice, for it is likely to affect others. Such delay may have impact on others' ripened rights and may unnecessarily drag others into litigation which in acceptable realm of probability may have been treated to have attained finality. A court is not expected to give indulgence to such indolent persons who compete with Kumbhakarna or, for that matter, Rip Van Winkle. In our considered opinion, such delay does not deserve any indulgence, and on the said ground alone, the writ petition should have been thrown the petition overhead at the very threshold. Malos, the whole writ petition, kindly see, there is not a single whisper as to why this delay. And you are not a person. You are an authority under Article 12 of the Constitution of India. And you are coming to the court after 5 years. That too without there being any explanation. And therefore, my submission is that the writ petition deserves to be dismissed on the ground of delay and laches itself.
You come to page 41 for a moment. You come to page 41 of this report, 9/6/2009.
41. Yes, madam.
establishment in spite of
demand of such returns, the same was not made available on the plea that they are not having such return with them. This act of the establishment
Such return means return of the employees.
TDS returns. I read from page 42. According to the above position, it is sound that all such categories of employee have drawn such annual salary which are very much taxable. If such category of employees were drawing such salary, the employer must have deducted income tax from the salaried employee and have deposited with an income tax return. Such details are given in quarterly return named TDS. The establishment, in spite of demand of such returns, TDS return, the quarterly returns is referred to.
Proceed further.
The same is not made available as the plea that they are not having such return with them. This act of the establishment indicates that the establishment has not actually paid such quantum of salary, and the same has been prepared only with a view to raise the quantum of wages salary for relaxation of balance sheet,
For
reflection of balance sheet. This has been done to save the establishment from income tax liability. In this way, the claim of the establishment regarding the excluded salary.
This has been done to save the income tax liability. No. This has been done to save them from the employees' PF liability.
In this way, the claim of the establishment regarding excluded salary is fit to be rejected. Hence, the amounts assessed under Section 7 of the Act while earlier order is fit to be reaffirmed by submitted for order.
That's all.
So this is one more point. First, that the ground of delay is fatal for this writ petition, and on this count itself, no, this should be dismissed. Next point which I want to raise before my is that the writ petition is filed under Article 226 here, challenging the decision of a tribunal. At best, he is claiming a writ of certiorari from this court. Now, whether in such circumstances, what my friend has invited to my lords, this paper, that paper, these papers he is reading, it's a writ petition. He should have supplied all these papers to me also. It's not appellate court that I'll go through the record only. If you are relying upon anything, you have to supply this to me.
Asked him to produce the record. Yesterday, your junior was there.
I'm not doubting that.
Just a
I'm not
moment,
doubting.
please. Yesterday, your junior was there. I handed over the entire records to him and told him that these records have been produced.
I don't dispute these things.
Yes. So
I cannot.
You see, there was a reason for calling for the records because
I'm not doubting this.
No. So therefore, you don't
Let
make
me-
an allegation that they should have filed it on an affidavit. They were not called
Plus-
upon to file an affidavit.
Kindly allow me to argue what I want to argue on this basis.
So don't-
Just facts I have said. Let me make my point. The first point I have made that this is barred by limitation. On this count, it should be dismissed. Second point I want to argue for that facts I am giving. Now, whether under Article 226 in a writ of certiorari, whether my friend is right in making all these submissions, for this purpose I rely upon a judgment. The judgment is reported in yours, 2003 volume 6 SCC, page 675. Famous case Surdev Rai, yours. Kindly come to para 10 thereof first. Whether in a writ of certiorari this kind of submission can be made. Para 10 is notes at report page 684. Para 10 notes I may be allowed to read. Article 226 of the Constitution of India preserves to the High Court the power to issue writ of certiorari amongst others. The principles on which the writ of certiorari is based, para 10, is issued are well settled. It would suffice for our purpose to quote from the 7-judge bench decision of this court in Hari Vishnu versus so-and-so. The 4 propositions laid down therein were summarized by Constitution bench in the case of so-and-so. The High Court was not justified in looking into the order dated 2/12/1952 as an appellate court, though it would be justified in scrutinizing that order as if it was brought before it under Article 226 of the Constitution for issue of a writ of certiorari. The limit of the jurisdiction of the High Court in issuing writ of certiorari was considered by this court in the case of Hari Vishnu Kama so-and-so and the law is laid down like this. Number one, in which case certiorari can be issued? Number one, certiorari will be issued for correcting errors of jurisdiction. My friend has not even argued, whispered, that the tribunal had no jurisdiction. Second is, certiorari will also be issued when the court or tribunal acts illegally in exercise of its undoubted jurisdiction, when it decides without giving an opportunity to the parties to be heard or violates the principle of natural justice. No case by my friend, no whisper in the writ petition nor in the course of argument that this writ petition will come within the purview of two. Third, the court issuing a writ of certiorari acts in exercise of a supervisory and not appellate jurisdiction. My friend wants your lordship to go into all these details. कि 5500 है, 1500 है, 1300 है, 1400. What is this? These are the records there that cannot be looked into under Article 226 for a writ of certiorari. The court issuing a writ of certiorari acts in exercise of a supervisory and not appellate jurisdiction. One consequence of this is that the court will not review finding of fact reached by the inferior court or tribunal, even if they be erroneous. I harp upon this verse, particularly verse 3. My friend has not come before this court that his case is within the purview of the parameters laid down by the abbess court. More particularly notes para 38.4 of the same judgment. 38.4. At report page note 694, it starts from right hand side 695 notes. I would place clause 4. Supervisory jurisdiction in the middle. Para 38 notes, clause 4 at page 695. Supervisory jurisdiction under Article 227 of the Constitution is exercised for keeping the subordinate courts within the bounds of their jurisdiction. When a subordinate court has assumed a jurisdiction which does not have, or has failed to exercise a jurisdiction which it does not have, or the jurisdiction though available is being exercised by the court in a manner not permitted by law, and failure of justice or grave injustice has occasioned thereby, the High Court may step in to exercise the supervisory jurisdiction. This is totally absent in this case. Next 5. Be it a writ of certiorari or exercise of supervisory jurisdiction, none is available to correct mere errors of fact or of law unless the following requirements are satisfied. Number 1, the error is manifest and apparent on the face of the proceedings, such as when it is based on clear ignorance or utter disregard of the provisions of law, and 2, a grave injustice or gross failure of justice has occasioned thereby. Submission before my lords is that even these two conditions laid down for the purpose of certiorari 4, 5 are not satisfied by the petitioner in the present case. And therefore, lords, on this count also, lords, the writ petition deserves to be dismissed. Lords, thirdly, and most importantly, my point is that rule has been quoted. This is the scheme of the Act, 1952 scheme, lords, which prescribes in explicit terms who are the excluded employees. Excluded employee you have considered, you have not heard that, no, we have not considered excluded employee. Therefore, where is the question of interference at this stage? And the order which my friend was placing, which was impugned in the tribunal. I would place for a minute this page 39. The order which I challenged before the tribunal. The finding I want to place once again.
Does the tribunal record anything regarding the impugned order's finding of the impugned order? Is the tribunal not required to at least reflect that this finding of the authority is incorrect? When an order is subject matter of challenge before the tribunal or before any court of law,
the tribunal has considered that this provision of law has totally been overlooked.
which provision?
5.2. 5 minutes. The provision which has been quoted at page 43, impugned order second page.
Yes.
That excluded employee का जो provision है scheme में, this has totally been overlooked by the this authority. That is a consideration by the tribunal.
No, overlook means what? They were considering the excluded employees only.
That is what the tribunal says. That you have considered those who are the excluded employees, which you cannot under the law. That is the basics.
the entire matter was revolving around whether these employees are falling under excluded employees or not. The reason which was cited by the original authority to pass an order, has that reason been met by the tribunal?
Because my submission is this much, that once the tribunal comes to the conclusion that you have considered those for the purpose of EPFO who are excluded, once this finding of the tribunal is there, and this is not under challenge before this court even that this is wrong finding.
They have said that it is a non-speaking.
Non-speaking order means mere saying. Once
It
the
is
tribunal
non-speaking,
says,
just tell us.
once the tribunal says
More.
merely because this is in 2 pages, that cannot be said to be non-speaking. It must be in 5 pages, 10 pages, but that is not the purpose. The
There
tribunal
is a
has applied his
finding-
mind.
There is a finding recorded by the learned authority that there is a falsification of record.
Now, that is why I
There
was
is a
taking.
finding in the tribunal that this finding is incorrect.
I am taking your lordship for this purpose only. That 47 I was referring to page 39. For that purpose I want to refer this. Kindly see to what extent this authority have gone into.
No, we will not.
As
we are
if-
not- I want to see the reason from the order passed by the tribunal. Because you say that the scope of certiorari is very limited. I think whatever be it, if an order is a non-speaking order, then certainly the court under 226 will also take into consideration.
Matters, I may be allowed to just place page 39 for a minute. This is part of the record, which has been set aside. Kindly see to what extent this authority has gone, as if he is the income tax authority. Finding के just नीचे I want to place. Page 39 and Excerpt 5. After going through the proceeding, records, petition, reply submitted by the establishment and the report of the departmental representative, and having applied my mind, it is found that the case is mainly concentrated on the issue regarding grant of benefits to establishment in respect of wages, salary paid to the excluded employees who were drawing more than 6,500 per month. It is observed, kindly see the observation of this authority. It is observed that the salary of the excluded employees were always rupees 1 lakh and above in every financial year. I pause for a minute here. It is the finding of the authority itself that the salary in a financial year of the employee was 1 lakh and above. Are you support at least?
आगे पढ़िए.
हाँ हम आगे पढ़ रहे हैं, हम कहे कि पॉज किए हम कंक्लूड नहीं
ऐसा
किए.
है कि पूरा आधा सेंटेंस पढ़ के या कमेंट मत करिए.
नहीं हम पॉज
पढ़
किए
के
खाली.
एक बार में
I have paused for a minute, just I am reading further. Which liable the employer to deduct income tax from the salary and deposit it with the income tax department, followed by submission of his prescribed returns. Now full stop here, I should pause at least. He is acting as if he is an income tax officer. You are mere EFO. You are bound by law, what is there in the EFO Act 1952, not more than this. If I have committed something wrong, if I have not complied any norms of income tax, the income tax authority will check me, not you. You do not have this power and jurisdiction. And when you have acted beyond your jurisdiction, then the tribunal is right to correct it. And that is what the tribunal has done in the present case, is my humble submission before my lords. Once you come to the conclusion that the wages paid to the employee is more than 1 lakh in one financial year, who are you to check it? This comes within the purview of excluded employee, so no, you are not at all entitled to pass this order. Is my humble submission before my lords.
और आगे जो है, the explanation, पढ़िए, the explanation of the establishment evidences that the employee
For non-production of these valuable quarterly returns by the establishment, taking shelter of its being 7 years old cannot be accepted. This is because as per the IT Act rules, again he is acting as if he is an income tax officer, which power he doesn't have. Rules record relating to minimum 7 years is required to be preserved. This can be said by income tax authority, not by you. The explanation of the establishment
Mr.
evidences
Manoj
that the employer has
Mr.
failed.
Manoj Tandon, इतना जोर से मत बहस करिए कि मेरा माथा दुखने लग जाए.
माइक तो
I am not hard of hearing.
अच्छा ठीक है. Now,
एकदम आराम से देखिए, इतना तेज बहस करने से मेरा सिर दुखने लगता
Madam, I'm slow. I will be
Yeah.
slow now. The
Yes.
explanation of
है. Your pitch should be enough for me to be audible, right?
the explanation of the establishment evidences that the employer has failed to deduct income tax from the salary and has not complied with the income tax department or has prepared fake salary register to evade grant of membership under the PF scheme. In this way, the request of the establishment fails, which was reheard as per the direction of the Honorable High Court. Accordingly, the dues under Section 7(1) of so-and-so, 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 so-and-so. So almost all this is being done by and at the instance of this authority only because this High Court set aside his order and remanded the matter back to him. He is bent upon to describe the view which he held earlier. Is my humble submission, and for that purpose only I read this. Nothing more.
So I just want to, last question to you. These findings, whatever it is, fake register, not register, does it find reflection in the order of the trial? That this finding was absolutely incorrect, or you could not have come to
May I
the
just answer
finding that
this?
it's a fake register.
May I just answer this? My submission would be that the tribunal was not required to go into this aspect. Once the tribunal came to the conclusion that you have included those who are within the purview of excluded employees. Once the tribunal comes to this finding, there is nothing more to be required to be gone into. Is my humble submission before my notes. Yes. So notes I submit. On the last occasion when I was arguing this matter, and when I took this point of delay.
I think I was not there at that point of time. So
No, what
please
I'm
don't
saying is-
refer to what you argued before another day.
And that is what I am repeating.
You have heard you. I have seen your judgment.
The
also.
last point I am taking. I may be allowed to take the last point.
You have argued on the point of limitation.
The third point is, when I argued this point, my friend has cited one judgment. My friend will give this judgment to my lords. That limitation does not apply as far as EPFO Act is concerned. I must
that
make
is
this.
in a different conclusion.
Yes, that is what I was saying.
That is in a different
Yes,
conclusion.
14B, for the purpose of 14B, there is no limitation. This judgment does not hold
That's right.
that for filing a writ petition there is no limitation. In a matter where there was only 4 years delay, the
आपके
Supreme Court.
फेवर में हाँ बोलने के बाद भी आप कंटिन्यू करते हैं बहस करना, तो ऐसा हम नहीं सुने हैं.
But the second judgment I have cited is that the orders of tribunals or postmortem should be reasoned. 2 judgments I have given on that. The second at flag C has actually quoted the first judgment of Assistant Commissioner versus Shukla brothers, and the relevant paras are quoted therein in detail at para number 3. That reason has to be ascribed by the tribunals. So this is a non-speaking order, and the tribunal is the last court of fact. I cannot agitate the issue of fact beyond the tribunal. So the finding on facts ought to have been arrived at by the learned tribunal.
Para number 20.
Now, flag C, the third judgment, passed in State Board Project Directors versus Saroj Maurya, calls out the relevant paragraph at para 3 of the said judgment.
heard the name comes before the parties. This petition has been filed for the following relief. The learned counsel for the petitioner, while giving the background of the case, has submitted that a complaint was received by the petitioner as contained in Annexure 1, and pursuant to such complaint, inspection was conducted and during inspection it was found that certain employees were engaged by the establishment, but they were not, but their PF contribution was not being deposited. He submits that upon verification of records, it was found that there was mismatch in the documents which were produced by the establishment. And the quantum of salary/wages shown in the balance sheet could not be supported with the records. There was, the report was dated 16/3/2007. There was another report dated 9/6/2006 with regard to examination of balance sheet for 3 years with reference to statutory returns under the income tax department.
May I take leave on the Micah's assignment again? It's my friend only here.
The learned counsel submits that thereafter a proceeding was initiated under section 7 capital A of Employees Provident Fund and Miscellaneous Provisions Act for assessment of, for determination of dues for the period from April 2003 to March 2007, and the same was challenged before this court in WPC number. What is the WPC number? 19, it is not legible.
WPC 1914 of 2000.
1914 of 2009, and it was observed therein that the assessment was done on the basis of the dues were determined on the basis of certain reports of departmental representative whose copies were not served upon the petitioner, and consequently the order passed under section 7 capital A was set aside and the matter was remanded for fresh determination. submits that upon fresh determination, the establishment was directed to submit the documents, and after granting due opportunity of hearing, the fresh order dated 27/2009 was passed, and the dues were quantified in the same manner as was done in the previous order dated 24/3/2008. The Learned Counsel submits that essentially the issue revolved around grant of benefit under the aforesaid Act of 1952 to those employees who, according to the establishment, were drawing salary more than rupees 6,500 per month. He submits that such claim was falsified in view of the fact that, in spite of repeated opportunities, the income tax returns, the quarterly returns of the income tax showing deposit of tax deducted at source of such employees with the income tax department was not produced by the establishment. Although the establishment was required to keep all the records regarding income tax for a minimum period of 7 years. And on that basis, a conclusion was drawn that either the explanation of the establishment with regard to payment of salary or was incorrect, or they had prepared fake salary register to evade grant of membership under the PF scheme. He submits that the establishment failed to satisfy the authority with regard to their claim that they were paying salary to 101 employees to the extent of more than rupees 6,500 per month. The Learned Counsel submits that the said order was challenged by the respondent employee before the Learned Tribunal, and the Learned Tribunal passed a non-speaking order by observing that in this case, salary register, income tax return and balance sheet revealed that such persons were receiving wages more than rupees 6,500. So the assessment of such persons could not be termed legal, and has set aside the order passed under section 7 committee. The Learned Counsel submits that the impugned order passed by the learned tribunal is non-speaking, and therefore the same cannot be sustained in the eyes of law. The order passed by the authority is a well-reasoned order, taking into consideration the documents produced / not produced by the establishment. The Learned Council has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2010 bracket close 4 SCC 785 para 24, 25 and 30, and also the judgment passed by Honorable Supreme Court in the case of State Project Director UP versus Saroj Maurya and others, passed in Civil Appeal number 3465 of 2023, paragraph number 3 and 5, and has submitted that the tribunal, the authorities including the tribunal are required to pass speaking order, and therefore the impugned order passed by the learned tribunal calls for interference. That is all.
And delay, my lord, I have said that.
I will just, that is in response to that.
Yes, yes.
The Learned Council, appearing on behalf of the respondent establishment, has opposed the prayer and has submitted that the writ petition has been filed after delay of 5 years from the date of the impugned order, and it suffers from unexplained delay and laches, inasmuch as there is no explanation and has relied upon the judgment passed by Honorable Supreme Court reported in bracket 2014 bracket close 4 SCC 108 paragraph 16, paragraph 15 and 16.
16 and 17.
Sorry?
16 and 17.
Paragraph 16 and 17. To submit that it is not open to any party to approach this court at their sweet will, and there being no explanation for delay of 5 years in approaching this court, the writ petition is put to be dismissed solely on ground of delay and laches on the part of the petitioner. He has also relied upon judgment passed. The Learned Council has also submitted that without prejudice to the plea of delay, the present writ petition, the petitioner is not entitled for any relief under Article 226 of the Constitution of India, wherein the petitioner is seeking a relief of certiorari, and the Honorable Supreme Court in judgment reported in bracket 2003 bracket close 6 SCC 675 para 10 has para 10 and para 38.38 within bracket 4 has explained the circumstances where a writ of certiorari can be issued. He submits that this court is essentially exercising supervisory jurisdiction over the learned tribunal, and no such ground has been made out by the counsel for the petition, by the petitioner in the petition or during the course of hearing to entitle the petitioner to a writ of certiorari. He has also relied upon a judgment passed by Honorable Supreme Court reported in bracket 2014 bracket close 4 SCC 108. ये 2014. These two judges.
हो गया ना ये वाला हो चुका है.
Bas only these two judges.
Yes. Actually, in the second judgment, we are also relying on 38 clause 5.
38 5.
4 and
4
5 both.
4 and 5 both. 38 within bracket 4 and 38 within bracket 5. The Learned Counsel has further submitted that the length of the order will not decide as to whether it is a speaking order or non-speaking order, but the Learned Tribunal has considered the applicability of the Act of 1952 and has observed that the persons whose salary was more than 6,500 in terms of the salary registered income tax return and balance sheet, they were required to be excluded, and therefore their assessment cannot be termed as legal. The Learned Counsel submits that no adverse inference could have been drawn against the establishment merely because the documents relating to income tax were not produced. There were sufficient documents to substantiate that that there were a number of employees who were drawing salary more than rupees 6,500 per month. He has also submitted that the Learned Tribunal has passed a speaking order and the same does not call for any interference. During the course of hearing, the Learned Counsels appearing on behalf of the parties have also referred to the documents which have been produced by the petitioner from the office of Assistant Provident Fund Commissioner, who has passed the order of assessment, who has determined the dues under section 7 capital A of the Act of 1952. In response, the Learned Counsel for the petitioner has referred to the judgment passed by Honorable Supreme Court reported in bracket 1998 bracket close 2 SCC 242 paragraph 20, 21 and 22 to submit that principles of delay and latches do not apply in beneficial legislation as money is held in trust by the employer, and submits that in the present case the writ petition may not be dismissed on the ground that the petitioner has challenged the order passed by the Learned Tribunal after a period of 5 years. In response to the aforesaid judgment reported in bracket 1992 bracket close 2 SCC 242, the Learned Counsel for the establishment has submitted that the same is in relation to raising of demand arising out of order of damages under section 14 capital B of the Act of 1952 from the establishment, and the same has no bearing in the matter of challenge to the order passed by the tribunal in writ jurisdiction. That's all. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, the aforesaid sequence of events, as has been narrated by the learned counsel for the petitioner, is not in dispute. This court finds that during the course of inspection, pursuant to the complaint, certain documents were produced by the establishment, and the authority noted that the director could not provide the records reflecting the quantum of salary / wages shown in the balance sheet. And there were certain mismatches. However, a proceeding was drawn under section 7 capital A of the Act of 1952, and it was claimed by the establishment that 101 employees were the persons who were drawing salary more than rupees 6,500 per month, and they fell in the excluded category. The said order was passed by the authority had rejected the plea of the establishment and recorded a finding that all such employees were required to be enrolled as PF members, and contribution and allied dues were to be charged at the rate of salary of 6,500 per month, and calculations were made. The said order was challenged before this court in the BPC number 1914 of 2009, and the order was set aside on the ground that the same was passed on the basis of reports of departmental representative without furnishing a copy of the same to the petitioner, and the matter was remanded for fresh consideration by the order dated 6/1/2009. The fresh order has been passed by Annexure 5 dated 27/2009, and it appears that after the order of remand, the establishment was asked to submit appointment letters in respect of all excluded category of employees and copies of Form 16 issued to such workers, TDS salary, sent to the Income Tax Department year-wise, payment register, salary statement, for the notice period, copy of agreement, work orders of the parties where they were deployed, and consequently on 16/2/2009 and thereafter on 16/2/2009 the establishment requested for supply of the reports submitted by the enforcement officer and the departmental representative, which was made available to them. On 23/2/2009, the establishment appeared and produced salary register and produced salary register of excluded employees for the period 1/2003 to 6/2004 and 1/2005 to 6/2007, balance sheet for 03-04 and 04-05, along with income tax returns. Later on, a petition dated 19/5/2009 was filed, and the departmental representative was directed to go through the petition and submit his comments and submit his report. On 9/6/2009, he filed a report dated 9/6/2009. A copy of the same was sent to the establishment, to which the establishment responded on 23/6/2009, and a reply was filed by the department. And further, a reply was filed on 23/6/2009. The authority observed that as per the wage register, the excluded employees were drawing more than rupees 6,500 per month, and the salary of the excluded employees were always more than rupees 1 lakh and above in every financial year, in which they were liable to deduct the income tax from the salary and deposit it with the income tax department, followed by submission of the prescribed returns. The quarterly returns were not produced by the establishment by stating that they were 6 to 7 years old, and such plea was rejected on the ground that as per the provisions of Income Tax Act and the rules, they were supposed to maintain the records for a minimum period of 7 years. The authority had drawn adverse conclusion against the establishment on the ground of non-production of documents relating to Income Tax Department, and observed that the establishment had prepared fake salary register for rebate grant of membership under the scheme, and ultimately repeated the order dated 24/3/2008, which was filed under Section 7 capital A of the Act of 1952. The records of the Assistant Provident Fund Commissioner has been called for by this court, and the report dated 9/6/2009 has been produced, which reveals that as per the salary register, a number of employees were drawing salary more than 6,500 per month, this has also been recorded in the order dated 27/2009. This court also finds that a large number of documents were produced by the establishment before the authority, including audited balance sheet and income tax returns and other documents which the establishment is bound to maintain as per different statutes. This court finds that the authority, the Assistant Provident Fund Commissioner, has rejected the claim of the petitioner that the employees were drawing more than rupees 6,500 per month. That large number of employees, to the extent of 101 employees, 101 employees were drawing salary to more than 6,000 per month, on the ground that the documents relating to income tax were not filed. This court finds that the said order was challenged before the learned tribunal, and the learned tribunal has recorded that there were documents to show that the employees were drawing more than rupees 6,500 per month, and has referred to salary register, income tax return and balance sheet, which revealed that they were drawing salary more than rupees 6,000 per month, and was of the view that the persons were not, that the assessment of such persons could not be termed as regular. This court is of the considered view that the learned tribunal has taken a view on the basis of materials available on record and has referred to the income tax return and balance sheet, which are maintained by the establishment under obligations cast under various statutes. This court is of the view that merely because the documents relate quarterly returns and documents relating and other documents relating to income tax was not filed, the same could not have been a reason to reject the other documents which were produced by the establishment, including the audited balance sheet and income tax returns. This court is of the view that the authorities have ample power to summon different authorities for the purposes of giving evidence before the authority. The Assistant Provident Fund Commissioner could have summoned the officers from the Income Tax Department to produce the records, but no such step was taken. This court finds that though the improved order passed by the learned tribunal is a short order, but certainly it is based on documents produced by the establishment. In considering the totality of the facts and circumstances, the impugn judgment passed by the learned tribunal does not call for any interference under Article 226 of the Constitution of India. The fact remains that the writ petition has been filed after expiry of 5 years from the date of passing of the impugned order passed by the learned tribunal, and in the entire petition there is no explanation on the part of the petitioner for such delay. Although so far as the delay, what's the judgment date? In the judgment passed by Honorable Supreme Court reported in bracket 2014 bracket close code SCC 108. The Honorable Supreme Court has observed in paragraph 16 and 17 as follows. इसको quote करते हैं. So far as the judgment which has been relied upon by the writ petitioner in the case of Hindustan Times Limited Supra, this court finds that the said judgment relates to action which could be taken by the employees under the Act of 1952 for realization of its dues from the establishment / employer, and the said judgment has got no bearing in the matter of delay and lattice with respect to the petitioner to challenge an order passed by the learned tribunal in a writ jurisdiction. कुछ छूट गया आपका बात? सारा कवर? आपका कुछ छूट गया?
Only one thing that Suryadev Rai has been partly overruled, not on this proposition, but on the part that it will lie against judicial orders, that has been found, which was relied by the respondent.
कोई जरूरत नहीं है ना. Delay and latches, that part is there, that is intact, that is a celebrated portion of the judgment. Merely on the basis of not filing certain documents of income tax, audited balance sheet को आप कैसे ignore कर सकते? And you only ask them to produce. You should not have asked them to produce. Anyways, this is my judgment. In view of the aforesaid findings, this petition is hereby dismissed. समझ में आया रिकॉर्ड किस लिए मंगाते हैं? लिटिगेशन को क्वाइटस देने के लिए. इतना जोर जोर से बहस करते दिमाग खराब कर. जरूरत नहीं है, हम आराम से सुनते हैं. आपको 10 कोर्ट में जाने की जरूरत है, मैं तो यहीं पर हूँ और मुझे कोई हड़बड़ी नहीं है केस डिसाइड.
I'll try to improve.
देखिए हमारे कोर्ट में ज़्यादा जोर से बोलने वाले को हम समझते हैं उसका केस खराब है.
I'll try to
Whereas-
improve.
It's not, but I'm just observing that it's really not. हम तो आराम से बोलते हैं, आपके ऊपर चिल्लाए हैं कभी आज तक? किसी पर भी कभी चिल्लाए हैं? Every litigation is a different litigation. आराम से सुन के ऑर्डर करने से litigation क्वाइटिस में पहुंचता है। नहीं तो बस रिमांड करते रहिए, देखते रहिए, there is no end to it. उनका एक ऑर्डर करना था। एक तो उनका ऑर्डर 4 बजे बोले थे ना।
Item 5.
और भी किसी का मेंशन हुआ है?
5.
सॉरी योर्स
Item 5.
जस्ट आज तो आपका लिखा नहीं पाएंगे लग रहा है, कल लिखा सेकंड। इसमें WPL 452 ऑफ 2006 मिस्टर लाला नहीं है यहाँ पर, उनको बोल देंगे प्लीज, सुबह ही लिखाएंगे, सेकंड हाफ नहीं, सुबह लिखाएंगे 10:30 बजे या 12 बजे लिखेंगे। Post this case to be taken up at 12. And your matter?
Since the September, there is an order by the honorable predecessor bench to file a report through an officer. The State Council in the morning has submitted that there was a meeting today with the department concerned.
They have not
They
yet
want-
filed a report.
They have to file it.
So we'll give you time. You are there? Madam, a report is to be filed
By the ST.
by this. There is a meeting with you also. I'm sure you must be a party in that meeting. So how much time is it expected?
Morning is sought for 2 weeks.
2 weeks.
2 weeks should be sufficient.
That's only one indication. One LA case has been referred in the counterfeit by the state, and that record is also has been called for in another writ petition in a different court. So that entire record has been supplied to the petitioners therein, and through those petitioners, day before yesterday, late evening, we got that record also. So with that clarity has to be brought on record from that particular record, that is the LA case of 6 of 1961. And that has not been placed by the state also, neither the NHA. So that record is there in the other writ
The
petition.
record which we are hunting for,
Yes.
which is that case
This
number?
is the petition is 4576 of 2022, and another petition is also pending with the same area with the WPC 1885 of 2021. So these are the two records which pertains to the same area, and only the issue is that the center line has been shifted, because of which the entire problems are here. The beach ka line se 75 feet they have to calculate. The center line once shifted, so that has been recorded in the LA case order sheet only.
Who had shifted the center?
The government authorities. NS division has acquired the land
They
for
must
NS.
have. They must have prepared a map
Yes.
for the construction. So shifted means there was a line, and thereafter they have shifted.
Yes, that is the trouble. First line was there, nothing, anything, not at
problem.
no. Now they have shifted. Therefore,
Which is the case number? So therefore, you would say that there should be more acquisition.
No, you're not.
they are saying that since the acquisition is so,
We have to hear them.
Yes.
They are in trouble. Right.
so this
If I
is the,
put your question, you will be in trouble.
So this is the
please hold on.
this is the writ petition 4576 of 2000.
I have noted. What is the record LA case number?
LA case is in exchange G. The counter affidavit is referred 6 of 1961.
6 of 1961. You were saying that this record is not available.
They have never placed it and neither informed the court previously also. Kindly have supplementary counter affidavit and exchange G, page 22. That has been referred in.
It was this case number or it was some other case number?
This is okay.
This one, which they are saying is old record,
Yes.
and they are not able to trace
Yes.
it. Where is it?
Annexure G, page 22, supplementary counter affidavit of the state.
LA case number 6 of 6160.
60. And that has been called by 31st October 2023 in the writ petition 457630.
And it has come in that record.
It has come on the record. The petitioner there have received the record also. But through those petitioners, day before yesterday, we have got the entire set of the record. It's a bulky record.
Records of LA case number 29 of 7172 is also required.
No, not in this.
Not in this case.
They are saying the petitioner's detail is not found in 1971 case LA case number. Now the dispute is with 6 of 1961, which they have referred in the NHG. It is there.
ये दोनों केस का स्टेटस देखिए. वो ये हमारे बोर्ड का है नहीं है.
नहीं.
But we can call for the records just for privacy, or
I
you
think
can just.
that's what the state is seeking adjournment for the 2 weeks. To bring on all the records on
The learned counsel for the parties are present. उनका भी memo of appearance ले लीजिए. He was there in the first half. The learned counsel for the petitioner submits that the records which relate to the present case is LA case number 6 of 1961-62. The records of that case has been produced before this court in another petition being WPC number 4576 of 2022, and there is another connected petition being WPC number 188 of 2021.
1885.
1885 of 2021. He has further submitted that the learned counsel for the state, he has further submitted that the report which was called for by virtue of last order has not yet been filed by the state. The learned counsel for the state has prayed for 2 weeks' time and has submitted that a high-level meeting has been called for the purposes of submitting a report before this court. Pose this case on बताइए कब रखें? November 12th, the report be furnished before this court by filing a supplementary counter affidavit latest by 11th of November 2024.
13th is the election years of the government authorities.
रिपोर्ट तो बना के देंगे ना भाई. NH का आपका स्टे चल रहा है भाई, आपको इलेक्शन याद आ रहा है. अगला 5 साल का भी इलेक्शन याद आ जाएगा जब स्टे रहता है.
The status quo.
At this, the counsel for the petitioner prays for extension of interim order dated 3/10/2024. The interim order dated 3/10/2024 is extended till 12th of November.
DPP.
You inform them that records have now been traced. है ना?
Serial
अब
number
क्या छूट गया?
78 was mentioned by me in the morning.
हाँ.
I have thought
78 क्या हुआ?
So, कल वही जो morning में matter आगे हुआ, वो similar matter है.
तो वो कब आ रहा है?
I was only praying that
When is that matter coming?
that is coming on Thursday.
Thursday. It will be posted on Thursday. ठीक है ना? वो रिकॉर्ड आया क्या? आपको पता है क्या मैटर है?
Yes, my lord. The same matter has been decided by your lordship.
So they,
Only in
all
that
these
light-
3 cases can be decided. I have posted it for final disposal.
Yes. बस tag केवल मैं.
Sorry, टैग नहीं करना. हर एक केस अलग होता है. ऐसा हम इस तरह से टैग करके हम ऑर्डर नहीं करते. Because every case is arising out of a different award, so every award has to be taken care of.
And this is also squarely covered by the decision passed by the judicial WPL number 2703 of 18.
2703
03 of 18.
of
18.
8.
And no LPA has been preferred.
The learned counsel for the parties are present. The counsel for the petitioner submits that the present case is squarely covered by judgment passed by this court in WPL number 2703 of 2018. the counsel for the respondent has submitted that similar matters are posted on next Thursday का date दे देंगे. He submits that this matter may also be posted on the same day, right? Post these cases on next Thursday under this case on next Thursday under the heading for final disposal. Record की जरूरत नहीं पड़ेगी इसमें. Counsel for the petitioner submits that the records of the learned labor court are not required for the
CGI
purposes
test
of disposal.
CGI test travel.
The concerned tribunals may
CGI
not be required for the purposes of disposal of the present case in view of the fact that the issue is already covered.
Maintainability.
एक इशू ठीक से डिसाइड करने से कई सारे इशू केसेस कवर होने लगे.
7 केसेस था, एक आपने डिसाइड किया और 6 है.
अच्छा.
और 6 3 का एक अलग बैच है इन विच मिसेस अहमदाबाद एंड सीनियर काउंसिल इज अपीयरिंग. एक में सर है और 2 अलग.
हम लोग ऐसे रश नहीं करेंगे. कोई मैटर कभी भी एलपीए में जाता है, सुप्रीम कोर्ट जाता है, सो वी विल नॉट रश. जब आएगा मैटर